Good afternoon. My name is Glenn Kantor, and I'm a founding partner of the law firm of Kantor Kantor. I want to present a webinar this afternoon to discuss both fire-related insurance issues, and the key point here is going to be when insureds do and do not need to retain an attorney or a public adjuster to assist them with their insurance-related fire claims. We will do our best to answer questions. Please submit them in the chat box, and I'll do my best to answer them at the end. Please try and keep your questions that would be of general interest. If you have questions specific to your individual case, please email me at the email on the screen. Luckily, my family was not impacted by the recent fires. However, that's not the case for my family with natural disasters. Back in January 1994, my family woke up to what we thought was a train coming through our house when the Northridge Earthquake hit. Within 24 hours, our home had been condemned. We had no place to live. At the time, I was a plaintiff's insurance attorney, but my focus was health, life, and disability, not natural disasters. I had never even read my homeowner's policy. I dug it out and looked at it and made a claim. However, over the next several years, I learned a great deal about insurance companies and natural disasters. From the '94 earthquake, I learned that Allstate was willing to have its adjusters use the stamp of an engineer over and over and over again when the engineer never looked at the property. I learned that State Farm was willing to forge its insured's names to reduce their policy coverage. I learned that farmers sent out a memo to its adjusters to bring back $1 billion because they were paying too much in claims. I learned that 20th Century was doing its best to open and close claims, so the statute of limitations under the 1-year provision of the policy, which no one was really aware of, would run before insureds learned the true extent of their damage. So once again, I've been there. I understand the pain you're going through. I was out of my house for 18 months. So we were very heavily involved, my law firm at the time, in litigating Northridge Earthquake claims. I represented hundreds of individuals and was involved in class actions. And I also learned that there were individuals who truly needed attorneys and those who really didn't, because their claims were paid and paid properly by the insurance company. Now, sitting here today, things are different. In '94, there was no internet. We met our clients through word of mouth and through community meetings. We were able to assure our clients that we knew how to deal with insurance companies. Today, many insureds are seeing advertisements to hire lawyers. They're told you need a lawyer right now. In some cases, the ads are making promises that aren't true or cannot be kept. And I want to discuss this morning considerations that victims of the fire should be making before deciding to hire an attorney. And if they do hire an attorney, how to go about doing it. Now, first, I want to talk about the insureds who just might not need to hire contingency lawyers, at least not yet. And I do want to talk about the difference between hiring a contingency attorney and hiring an hourly attorney. If you hire a contingency attorney now or a public adjuster, they are going to almost certainly take a percentage of every dollar they get for you. Meaning, if the insurance company is just going to start paying you money, they're going to take a percentage. Compare that to an hourly attorney who might be able to, for a relatively small amount of money, sit down with you or even do it via Zoom and explain basic policy terms, your declarations page, to explain the coverages you have and the things you should do to best proceed with your claim. Now, I believe that the single largest category of homeowners who are going to have problems arising out of the fire were those who are underinsured. Many people, I'm just hearing horror stories about people who bought their homes 10, 15, even 20 years ago and have never adjusted the amount of their coverage. And as we all know, costs in all areas have arisen. Well, somebody may have purchased $500,000 of dwelling coverage in 2005. The coverage they purchased in 2005 is not going to be sufficient to rebuild or replace their home. Now, what may happen is the insurance companies may look at that property and say, we know this coverage is not adequate. We're just going to pay you out. We're not going to spend the time to adjust your claim. We're just going to pay your benefits, including living expenses, personal property, and the dwelling coverage. They just want to be done knowing that you're underinsured. If that's the case, there's really no reason to hire anybody to help you. Talk to the insurance company. If they agree, they're just going to pay you out. And the money that's going to be truly insufficient to rebuild your property or replace it will all be in your pocket. It won't be reduced by having to pay an attorney or a public adjuster. Now, as I'll discuss later, there are exceptions with regard to underinsured homeowners. It's a tough row to hoe. The law is going to be against you, but there are going to be exceptions where people are uninsured, have arguments that it was the insurance company's fault, not their own, that the insurance was not adequate. You may have a very cooperative insurance company. I like to tell people, when insurance companies properly pay claims, nobody comes to my door and says, you know what? The insurance company was great. Will you sue them? It doesn't happen. I see in my office people whose claims have been denied. So I don't want to improperly malign all insurance companies. Some are going to be fair, and you may not need the assistance. You might, as I say, you may find a cooperative, sympathetic claims adjuster who's going to tell you everything you need to know and assist you in getting your claims paid. If that's the situation, once again, you probably don't need an attorney. And before hiring one, you might find out just how cooperative your insurance company is. Of course, there's going to be insurance companies and claims adjusters who start out being cooperative. We feel bad for you. We want to help. Here's an advance on your living expenses. Here's an advance on your personal property. Here's an advance on your dwelling coverage. And they sound great. Once again, I'll discuss later, those things are obligations under California state law. So they may seem to be cooperative, but aren't necessarily. And in this case, you may be better off taking what they're giving. If they're going to give you money at the start, there's no reason to be sharing that with an attorney or public adjuster. Take what you get. And if then the insurance company stops being cooperative, if they start questioning the home you purchased, the home that you are renting to replace your own home, or they're saying, no, you haven't given us enough evidence for your personal property, or we don't think it's going to take as much to fix your home as you do, then that might be the time to hire an attorney. So as I said, I can almost call the initial money you're getting from the insurance company low-hanging fruit. You're going to get it, they're going to give it to you. There's no reason to hire a contingency attorney to help you get the money the insurance company is just going to give you. Now, if you are going to handle things on your own, I'm just going to give you some tips on And these are basic tips on what to do to protect your interest, to make sure that you haven't fallen into a loophole that's going to allow the insurance company to pay you less than you're owed. Every attorney is going to tell you when you're dealing with an insurance company, put everything in writing. If you have a conversation with them, which I'm going to advise against, but if you do, confirm it in writing. If there's important documents that you want the insurance company to have, you can email them, but ask them for a confirmation that they got it. If you're going to put something in the mail and it's important, it could be an engineer's report that you obtained. It could be a report about the toxins in your home, something that you really want the insurance company to have. Our advice is send it via certified mail. Go to the post office, they'll give you a simple document to fill out called a green card. And in order for the insurance company to take it out of their post office box or get it from the post office, they'll have to sign they received it. So there'll be no issue down the road with the insurance companies saying, oh, we never got that document, because you'll have that signed green card saying, yes, you did. Now, the insurance company may have your cell phone. They may, out of the blue, call you up. You won't know it's coming from an insurance company. You won't really be prepared to talk to them, but you've gotten a call. And you don't want to be rude, or most people do not want to be rude and just say, I'm not talking to you. So you'll start talking. Some quick advice. Insurance companies will often record these calls. And if you call them, it's going to say on the helpline, these calls are recorded for quality assurance. Well, that's not the reason they're recording them. They're recording them so they have a record of what was said. You're never getting that record unless you end up in litigation down the road. If the insurance company is going to record you, you should record them. Anybody who knows how to use an iPhone or a cell phone should be able to record it. My colleagues would tell you, I wouldn't know how to do it, but it's not hard to figure out, or so I'm told. But another piece of advice, don't record anybody you're talking to from an insurance company or anybody else, to be honest, because it's not legal in California to record somebody without asking them first. And you should get their permission on the recording so there's no question that they know they are being recorded. Anybody who has nothing to hide should have no objection to you recording them. They may be a little less forthcoming in what they're going to say because they know they're being recorded, but that's okay. You want to know the accurate answers, and if they're not going to be able to give you an accurate answer, that's okay. You'll get it later directly from the insurance company. I've been using some terms, and I should probably explain them. People talk about their agent, their claims handler, and their adjuster. Those are all different things. The agent is the person that you went through to purchase your homeowner's coverage. It could be a captive agent of the insurance company where they only sell for that particular company, or it could be an agent that sells for many companies. In any event, the agent that you purchased your insurance from should be able to get you a copy of your policy, and they should be able to explain to you the basics of your coverage. They're supposed to be experts in this area. Unfortunately, you may have purchased your coverage 10, 15 years ago, and the agent's no longer around. But if they are, they should be an advocate for you. Now, there's a claims handler. That person works directly for the insurance company. They'll have access to your policy, they'll have access to your claims file, and they should be the ones who should be able to answer your questions about your coverages and about your claim. When you talk to them, if you get answers to questions, ask them to confirm it in writing, and if they don't, you should do it. Then there are what are colloquially called just adjusters or CAT adjusters, and that stands for catastrophe adjusters. These people are interesting. They're somewhat of nomads. No insurance company can keep these people on staff in the potential of event of natural disaster. So these catastrophe adjusters go around the country from natural disaster to natural disaster, whether it's hurricanes in Florida, tornadoes in Oklahoma, or floods in Missouri. They go around adjusting claims. The problem there, many different problems. One, they're not going to be familiar with California law. California law probably provides more protection for its consumers and insureds than any state in the union. So they're not going to know all the protections that you have. They're also not going to necessarily know your policy, the terms of your policy, and how your particular carrier is going to interpret those policies. So your adjuster will be looking at your damage. He'll be discussing your damage with you. He'll be discussing the damage with anybody you hire to represent you, whether it's a contractor or an expert on toxins in your home. The adjuster will be talking to these people, but the adjuster is not the person to be talking to about your coverages. Now, some of the attorneys that you might be talking to may have a great deal of knowledge about insurance policies and the laws that have been passed recently in California to provide extra protections to individuals whose homes have been damaged in a natural disaster. And there are statutes I'll talk about which only apply to individuals with insurance problems stemming from natural disaster. They don't apply to a single home that happened to burn down because of an electrical problem. They apply when the federal or state government has declared a disaster area. Obviously, we all know anybody whose home was burned down or has smoke damage from either the Eaton or the Palisades fire, both of those areas were declared national disaster areas. First thing I would tell people, you have any kind of damage, open your claim immediately. There's no reason whatsoever to delay opening your claim. Under California law, if the fire in your area occurred on January 16th, the statute of limitations starts to run the day of your fire. Now, what's interesting is it only runs from the day of your loss until you advise the insurance company you have a claim. Advising the insurance company in California of a claim stops the statute of limitations from running. And I guess I should explain. A statute of limitation is how long you have to bring suit against the insurance company in the event that you can't reach agreement on the extent of your loss, or if you believe the insurance company breached your contract or acted in bad faith. So I'm going to go back to the Northridge earthquake for a second, in that no one, and I mean no one, insureds and even the attorneys handling these claims were aware that homeowners policies in California uniformly have what's called a 1-year contractual limitations period. The statutory limitation period is 4 years for breach of contract and 2 years for bad faith. But the insurance policies have a 1-year limitation, such that many people back in the Northridge earthquake waited too long. The insurance companies opened their claim quickly, they closed it, and a year later, maybe their roof was leaking, smoke was coming out of their chimney, they were finding cracks in their foundation, and they would call their insurance company back and say, I found more damage. And the insurance company's response was, we're sorry, your 1 year is up, we're not doing anything. Now, there are laws that will protect you in that instance. There's a 30-year-old case that says, and this is what I'm talking about, from the time you open your claim until it's closed, that statute is not running. But every time they close it, the clock continues to run. So if it's opened 5 times and closed 5 times, for every period in which that claim is closed, the insurance company is going to be keeping track of how long you have to bring suit. After the Northridge earthquake, the legislature enacted a special law applicable only to the Northridge earthquake, giving people 3 years. But we don't know if that's going to apply with regard to the wildfires. Probably not, because in the earthquake, a lot of the damage was hidden. If your home's burned down, there's not much to hide. Now, I spoke about extra protections provided to the victims of natural disaster. When you make a claim, especially if your home is burned down, you may have escaped with nothing but the clothes on your back. California law provides a somewhat complicated formula of what insurance companies have to give you immediately if your home was destroyed in the fire. They take the dwelling coverage, which is what the basic coverage to rebuild your home, and they have to give you 30% of that amount for your personal property coverage up to $250,000. That's the max. They can't require evidence of actual damage. They have to give you this money. So going back to my discussion about, do you need to hire a contingency lawyer at the start? Well, if you do, that lawyer may take a percentage of that 30% or up to $250,000 you're going to get from your insurance company. Another law that was passed to protect victims of natural disasters. Your policy is going to give you 24 months at a max to submit evidence of damage. That may be that you're rebuilding your home and you can't get it done in 24 months, or you've got personal property. You can't itemize it all in 24 months. The statutes require that they give you at least 36 months. Another statute that is applicable: your home is burned down. You have no place to go, and you may not have the money to pay to either rent a house or go to a hotel. If your home has been destroyed, you can't live in it. You have a forced evacuation by the government. The insurance companies have an obligation to advance you at least 4 months of living expenses. Once again, that's your money. It's going to be given to you by the insurance company, and you shouldn't be paying anybody else to get it for you. Another piece of legislation that I think is really key is that while you have the right to rebuild your home on the same site, you don't necessarily have to rebuild it. Insurance companies are going to talk about in the policies that they're going to pay the cost of repair. That's going to come in for folks who've got smoke damage, rebuild if your house was destroyed, or replace. And replacement is really important in that what we've learned from past natural disasters is a high percentage of people do not rebuild their homes in the same spot. It's going to take too long. I talk to people in their 80s that say, I can't wait the 3 years. I just need to move on. But the insurance adjuster is telling me, in order to get all the benefits of my policy, I have to rebuild the house on the same site. That's not accurate under California law. You have the right to rebuild if you choose to, but you also have the right to replace your home with another home that is going to cost what it would have cost to rebuild your home. And one significant advantage that is also in the legislation is that you get to keep the land your home was on. Because when you buy a new home and you do replace it, you're going to be paying for land. So you get to keep the land and do what you want with it if you do replace your home someplace else. One area of legislation which was supposed to provide some protection with regard to underinsured homes, but really doesn't, is the section of law about what is the coverage that has to be provided. You'd like to think that the insurance company would know what it's going to take to rebuild your home and would tell you. But the law is in California, you have to ask. It is the burden of the insured to be telling the insurance company how many square feet they have, the quality of their home. A newly built home in the Palisades may be of a much higher quality and may cost much more to rebuild per square foot than a home in another area. So you've got to be telling the insurance company when you purchase your coverage, or telling the agent how many square feet you have and the nature of your home. It's not their burden. Now, that burden can shift if you place the onus back on the insurance company. We'll discuss that a little bit later on in the presentation. So, once again, I'm going to recap. Open your claim now and keep it open, because the statute of limitations is told while the claim is open. If the insurance company writes you and says, we're closing your claim, your response needs to be in writing. No, I do not want my claim closed. I'm not done. You need to keep it open. And the other slides pertain to the protections that I was talking about. One protection that we're not sure is going to happen is with regard to homes damaged by smoke, and potentially smoke that contains toxins. It's not just smoke with a smell. It is smoke containing toxins, which in some ways has poisoned your home. It may have made the clothes in your home unwearable, the porous couches in your home not safe to sit on, the carpeting and the drapes soaked with toxins. They need to be replaced. There have been cases from the courts of appeal in California that we believe stem from COVID, where the courts did not want to place the onus on insurance companies to cover every business they had to close because of COVID, because they felt the insurance industry could go bankrupt. So the courts have said, well, merely smoke is not a covered event because it doesn't cause physical harm. However, the California Department of Insurance, led by Insurance Commissioner Ricardo Laura, has issued a bulletin, 2525-7. It can be very useful to you. It's easy to find on the internet. That is basically saying, we've examined the case law that says smoke is not covered. It does not apply in this situation. If you have toxins, that is physical damage, and it's going to have to be covered. Now, it's only been several months, but I'm already hearing stories from potential clients and actual clients saying, my insurance company is saying, no, they're not covering my smoke damage because they have no evidence that there's any toxins in it. Well, it's the insurance company's obligation to investigate your loss. They shouldn't be saying to you, go out, hire a company to determine if there's toxins, and if there is, we'll come in. Or, you know what, you sweep out your home, you do what you can. If you still think there's damage, call us. That's not the way it works. The insurance company has the obligation to investigate your claim. Okay. So we talked about understanding the basics of the laws which were passed to protect your interest. The statutes giving the right to replace your home and keep your land. I want to talk about the land for a minute. I'm also hearing, maybe it's a myth, but I'm not so sure, that there are developers who are rushing into Altadena, Pasadena, particularly the Palisades, trying to purchase people's land now. I think they're trying to sweep in and get them inexpensively, or purchase the land inexpensively. I suspect what they're going to be doing is trying to purchase 3-4 properties in a row and take what were small houses and build what I might call a McMansion. Whether the government allows them to do that, we'll see down the road. but don't rush into selling your land. This is an area where waiting is going to benefit you. And you may need a realtor to advise you what the true cost or the true value of your land is. And conversely, I said that the developers may be looking to purchase 3 or 4 properties together. Well, if they're doing that, it may be best for you to band with your neighbors and get together and sell 3 or 4 parcels to a developer. Okay. Once again, go to your insurance company, ask for the advances that you're entitled to. With regard to personal property, the law prevents them from asking for itemized billing. With regard to every single item in your home, you're allowed to submit bulk bills. Also, so you know, there is a piece of legislation in the California legislature which would require insurers to pay 100% of your personal property coverage without requiring itemization. It's a great bill if passed and if enforceable. Personally, I'm concerned that it might not be constitutional if passed retroactively. The insurance carriers will claim it's an impairment of a right to contract with you. I think they'll fight very hard not to let this bill get through or not to allow it to be retroactive. Almost all policies are going to contain additional living expense provisions, which is intended to provide you money to live elsewhere because you're probably still paying the mortgage on your home. The insurance policies are going to max that out at 24 months, but the legislation in a natural disaster requires them to give you up to 36 months. However, and this is an important caveat, while you have extra time, you don't get extra money. So if it's going to take you 3 years to replace or rebuild your home and you've got $300,000 limit, you've got to make that $300,000 stretch over 3 years, not 2. So when looking to rent a home to live in while you're rebuilding or replacing, keep that in mind. You may not be able to afford a home with the same quality, size, location that you were living in before the fire. One quick additional tip, if you've got a smoke damaged house and the adjuster comes in and tells you you've got no problem, it's just smoke, there are no toxins, and you were lied to, that lie will toll the statute of limitations. They can't use that against you. However, if you're given information that is not completely accurate about the interpretation of your policy, that's on you. So if you've got questions about your policy terms, that might be the time to hire a lawyer to assist you. But as I'll talk about later, hire a lawyer by the hour. It won't, an experienced insurance lawyer should be able to look at your policy, take not more than an hour, mostly at most 2, and tell you or give you the answers to your questions. Besides lawyers, there's a lot of resources out there that are there to help you. One in particular is an organization called United Policyholders. It's existed for 35 years, and it has one purpose: to advocate for insureds, policyholders. It was established by a woman named Amy Bach, who, I have to be honest, is a very close friend of mine. She's an angel from heaven. She has dedicated her professional life to advocating for insureds. They're a nonprofit. They don't take money from insurance companies. So they'll have information for you. They'll never charge you. They have an excellent website that will have a lot more information than I can provide here in an hour. But it's on their website, and they also have people who will answer your questions. And if they can't answer them, they'll send you to a lawyer who's going to volunteer to answer it for you. They'll also provide a list of lawyers who are what they believe experts in insurance. They've vetted them. And I think if a lawyer is on their list, you should be comfortable that that's a good lawyer for you to hire. Okay. Now, I've talked about people who might not need to hire an insurance lawyer right away. There are going to be people who do need to hire them, either a lawyer or a public adjuster. The first group of people are those who just can't help themselves. We have senior citizens, people, not to be ageist, in their 80s who say, I just can't do this anymore. I'm not able. It might be people in their 40s who just feel overwhelmed. They can't do it. And they want the assistance of an attorney or a public adjuster. If the only issue is what is the cost to repair, a public adjuster is fine. Do your research, find a good one, and that might be appropriate if you really can't help yourself. Now, I talked about underinsurance. For the most part, people who are underinsured are not going to have a remedy, but there are going to be exceptions. If you said to your agent, and you've got anything that can prove it, I want to know, am I properly insured? And you asked over the years, and the answer was yes, you're fine, but it wasn't true, you may have a claim against that insurance company via the agent's misconduct or negligence. But once again, the burden is on you, but the burden will shift if you ask the carrier to give you an update as to the current replacement cost for your home. There are some other potential theories. I think they're great theories, but I'm not sure what the law is going to do about them or what the courts are going to do about them. My colleagues believe that the insurance companies knew people were underinsured. They knew that the estimates for the per square foot cost to rebuild a home were grossly understated. They did nothing about it. But to date, the courts have not allowed people to pursue carriers on that basis. This fire may be different. Okay, I've talked mostly about homeowners whose homes have been destroyed. There's not going to be a lot of issues about the damage. It's evident your home was there, now it's gone. Smoke damage is different. I talked a little bit about the cases that have been decided saying mere smoke may not be covered under your policy. But as I also talked about, the Department of Insurance is saying if there's toxins in that smoke, they believe it's going to be covered. And I personally believe that the courts are going to support that, and that any insurance company that says, well, you may have toxins, but it's not covered under these cases is going to lose in court and lose badly. I think an insurance company taking that position will have acted in bad faith. Once again, the insurance companies, it's their obligation to provide you a full and fair investigation. They have to investigate and they have to bear the cost of that. Caveat, you might not want to accept the people that they're going to send out because they may be looking, to be honest, to not find toxins rather than find them. So it may be better that you insist that the insurance company reimburse you for the company that you hire. You need to remember that, invisible things in your home, the toxins, can be very dangerous. It's comparable to mold or asbestos. You don't want to live in a home that's got toxins. The Department of Insurance has taken a position on this, and if you have questions, I provided the hotline, and they'll be there to give you answers. If you do decide you need a lawyer, some quick tips on how to do it. You want to make sure you're looking for an experienced attorney or a firm with experience in dealing with casualty losses and insurance-related casualty issues. I believe there are some lawyers out there who are just advertising who don't have the requisite experience. When you talk to a lawyer and they tell you this is our fee, don't assume that it can't be negotiated. If your home is extremely expensive and a contingency fee would be a lot of money, most attorneys are going to be prepared to negotiate, so you hire them and not one of their competitors. However, once again, another caveat, don't necessarily take the lawyer who's going to charge you the least amount of money. There may be lawyers out there who are looking to sign up fire victims, settle their cases quickly, and move on. So, the old saying is, you get what you pay for, can be true here. You'd rather pay more to a competent, experienced, aggressive attorney who's going to get you everything you're entitled to, rather than an attorney who's looking to take on as many cases as they can and just settle them quickly. That is not in your best interest. Shop around, get referrals, look online for attorneys with good recommendations. I would suggest you never hire the first attorney you've spoken to, at least get a second opinion. They may tell you, as I did, you may not need an attorney yet, or they may say, yes, you do, here's what I do for you, and here's what I'm going to charge you. And then you make your decision. Okay, I've been talking about insurance issues. There are other reasons to hire an attorney. If you had to flee because of the fires, you were evacuated, or your home suffered damage. Anybody in that position is going to suffer significant emotional distress. You feared for your life. Your kids are now not in the same school. You may be living 40 miles from your job, and you've got to commute. Insurance companies are not going to be paying for those kind of damages. It's just not part of the policy. However, if a lawsuit is brought against, for example, Edison, if they are found to have started the Eaton fire, then they will potentially be responsible for paying for your damages, the damages that are beyond what your insurance policy pays. As I said, underinsured, the entities such as Edison or public entities may be responsible for making you whole. The issues on how to hire somebody are identical to those on hiring counsel to hire insurance issues. There's going to be very large firms who are very competent, who have experience in doing this, and there's going to be large firms who are out there to take on as many cases as they can and settle them quickly. Most likely, as in prior fires, there's going to be a committee of lawyers who get together. There'll be a settlement process, and you'll go through that process. So hiring a large firm is not essential. You can also hire a small firm who will give you more individual attention. In conclusion, I want to summarize some of the things I've said. First, don't rush. Not to make a bad pun, but wait for the smoke to clear. Ask the questions you need to ask of your insurer, and don't stop until you get the answers you need. This is our community. I live in Northridge. I wasn't affected by this fire. I was affected by the Northridge earthquake. I basically understand what you're going through. I want to thank you for taking your time to listen to what I had to say today. And really importantly, I want to thank the community and everybody within it for supporting each other. This is a difficult time, and together we'll all get through it. Thank you, and now I'll take any questions that are presented.